the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Good day, everyone. Welcome back to Case Files, where we take real fair housing cases and we break them down into practical lessons for housing professionals. My name is Jonathan Sarr, a property management education specialist, and with me today is fair housing attorney and national speaker, Leslie Tucker. So Leslie, looking forward to our show today. Today's case is one that really hits at the foundation of fair housing compliance. Literally, we're talking about accessibility in new construction. So the case is Fair Housing Justice Center versus Whiten Developers. This was filed in federal court in the Eastern District of New York. The complaint involves two Brooklyn apartment buildings, Cypress Park and the Agora. And before we go any further, a quick legal note. This is an open case, which means at this point, these are allegations made by the plaintiff. There's been no ruling on whether the defendants have violated the law.
Correct. And of course, that distinction matters a lot. But even at the complaint stage, this case gives property management professionals, I think, a lot to think about because it identifies specific physical features that the plaintiff says made the properties inaccessible to people with mobility disabilities.
So let's start with the big picture, Leslie. What is the Fair Housing Justice Center alleging here?
The FHJC alleges that the developers, owners, management company, and architect failed to design and construct these two multifamily buildings in compliance with accessibility requirements under the Federal Fair Housing Act, the New York State Human Rights Law, and the New York City Human Rights Law. So this covers federal, state, and local law. The complaint says that the buildings had inaccessible common areas, unit features, problematic thresholds, doors that were allegedly too narrow, right? A bunch of different things that were not in compliance with the applicable rules.
Okay. So it's not just an isolated issue like, well, one resident asked for a ramp and the request was ignored. This sounds a lot broader.
Yeah, much broader. This is a design and construction case. The allegation is that the buildings themselves were constructed with barriers, multiple barriers that limited access for people with disabilities. Under the Fair Housing Act, covered multifamily dwellings, like these two, built for first occupancy after March 13th, 1991, have to meet certain accessibility requirements. Under the Fair Housing Act, that includes accessible routes through common areas and the units, usable public and common areas, doors wide enough for wheelchair passage, accessible environmental controls, accessible bathrooms, and kitchens.
Okay. And that date is important because, sometimes people, they still talk about accessibility as if it's new, like it's a new trend or it's a new best practice, but this has been around for decades.
Right. Yeah, these requirements are not new at all. They've been a part of federal fair housing law for a long time now, and that kind of makes it harder for, housing providers and developers to argue that accessibility was somehow an afterthought or, an unclear obligation.
Got it. Okay. So let's just take a minute, Leslie. We can talk about some of the specific allegations because I think this is where the learning really comes alive for property managers. So one issue mentioned in the complaint was mailboxes. So in one of the properties, testers allegedly measured the top row of the mailboxes at 50 inches from the ground to the top keyhole. The complaint says that it exceeded the required 48-inch height. Now, to someone outside the industry, that may sound like a small difference, but Leslie, why does something like this really matter?
It matters because accessibility is it's very much measured in inches. A mailbox keyhole that is, you know, too high might be unreachable for someone who uses a wheelchair or someone with limited reach. The same is true for thermostats or light switches or handles, other controls like that. The legal issue is not whether the feature was close enough, right? The question is whether the property provides equal access and usable features as required by the legal standard.
Got it. So that's a great phrase. Accessibility is often measured in inches. So another issue that was mentioned on the complaint was trash disposal. So the complaint alleges that garbage chutes had T-bar handles that were not accessible to individuals with limited hand strength or dexterity. So for property managers, this is one of those everyday things we might overlook. Taking out the trash is really, it's such a basic part of living independently.
And that's exactly why it matters, right? Fair housing accessibility is about the use and enjoyment of the community. If a resident can't independently access the trash chute because of the hardware on it, that's not just a maintenance detail. And notably, accessibility codes do speak specifically to permissible hardware standards and designs.
Okay. Okay. The complaint also focuses heavily on thresholds and amenity spaces. It says the roof deck at one of the properties had a step up and no alternate accessible route. It also alleges that entrances to areas like the laundry room, co-working space, screening room, and the bike room had thresholds or steps that exceeded accessibility limits. And at the second property, the complaint alleges that barriers at amenity spaces, including a laundry room threshold, business room, co-working space, outdoor courtyard, and other common areas. Interesting.
Yeah, and that's important because if you advertise a roof deck, right, a co-working space, all of these different amenity spaces, all of those spaces are part of the housing experience for your residents. And therefore, they have to be accessible to all of your residents, including those with mobility disabilities.
Okay. So for our community, big operational lesson. A lot of communities promote amenities as a selling point. But if your marketing says, enjoy our rooftop lounge, and there is no accessible route to get to there, well, now there's a disconnect between the promise and the reality. Is that correct, Leslie?
Yeah. And that disconnect there between the promise and the reality can become evidence in an accessibility case. The accessibility of your property should be reviewed before those amenity spaces are marketed or opened or celebrated, right, as part of the resident experience.
Got it. Okay, continuing with the complaint. It also includes allegations about individual units. So some doors leading to terraces or balconies were measured at widths the complaint says fell below accessibility requirements. It also alleges that some bathrooms did not provide enough clear floor space for wheelchair maneuverability, and one tester who used a wheelchair reportedly could not maneuver and close the bathroom door behind her.
Right. And compliant door size and bathroom maneuvering space are both features that are specifically required under the Fair Housing Act. It's important to remember that, accessibility isn't just about getting through the front door of the building. Of course, that's important too, but it's also about whether a person can actually use the dwelling. Can they enter and move through the entire unit? Can they access that balcony or that terrace? Can they reach the controls, right? Those questions should be part of the compliance conversation long before a resident, complains about it.
Nice advice. Thank you. Comments there. So let's talk about the defendants for a moment, if that's okay. The complaint names owners, developers, a management company, and an architect. So why is that so important?
Because fair housing design and construction liability can reach multiple participants in the process: owners, developers, builders, architects, and others involved in design and construction. They can all face claims depending on what their role was in control over the project. The complaint also alleges that each defendant had an independent, non-delegable duty to comply with fair housing accessibility requirements.
Okay. So I like that phrase you used, non-delegable duty. It's one that property management professionals, they should pay attention to. Definition, it means you cannot simply say the architect handled that, or the contractor signed off, or the city issued a certificate of occupancy. Those correct statements, Leslie? What do you think?
Yeah. And what you just said, a certificate of occupancy, that doesn't automatically mean that a property complies with the Fair Housing Act. Building code approval and fair housing compliance are related, but they're not the same thing. Property management teams, from their perspective, because they can be named in these complaints, right? They often inherit these buildings after construction, and most had absolutely nothing to do with the design and construction of the building. So, does that make them completely safe from an accessibility lawsuit? No, it doesn't. Although, they would certainly have a defense if they were named. But it's important that management companies are at least aware of potential accessibility non-compliance issues that exist in their building, because this is something that a resident may ask you to correct down the road, or worst case scenario, you might be named in a lawsuit. So being aware and being on notice of those deficiencies ahead of time, I think, is really important.
Okay, very good. Thank you. So next topic then. Let's focus on testing. So according to the complaint, FHJC used testers who posed as prospective renters and took measurements during tours. So what should property managers learn from that?
Well, as many people know, testing is a common fair housing enforcement tool. Testers could call the property, they could email, take a tour, ask questions, or even document physical conditions. In accessibility cases, they could take measurements of thresholds, door widths, mailbox heights, or even take pictures of those things. But keep in mind that the lesson is not, watch out for testers. The lesson is to, operate as if every prospect deserves a fully compliant experience, because they do.
Solid teaching point. Yeah, thank you, Leslie. That was really great. So let's shift now into practical takeaways. So if a property management company is listening to this, and we know you are, thank you, awesome community, and they manage newer multifamily housing, what should they do?
Well, first, I wouldn't assume that new equals compliant. New construction can still contain accessibility problems depending on the design and construction of that property. Second, it might be a good idea to kind of audit the full resident experience. That means the leasing path, entrances to amenities, the mailroom, the unit doors, getting through the unit itself, and any other resident-facing space. Third, document any concerns that are reported to you that you personally observe, and escalate those concerns. Property managers may not be architects or accessibility professionals, but they are often the first to notice those types of recurring barriers. Fourth, bring in, someone qualified, a qualified accessibility professional, if you suspect that there may be an issue or when these things are reported to you. Guessing about it, making assumptions is risky. And there are a lot of accessibility standards that a lot of housing professionals probably aren't aware of.
Great takeaways and nice practical thoughts. Thank you, Leslie. And from the education side, another thought to consider: train the whole team to recognize those red flags. So a leasing consultant may notice that a wheelchair user cannot access a rooftop amenity. A maintenance tech may notice that the threshold is unusually high. A manager may notice repeated accommodation or modification requests tied to the same physical feature. Those are not just isolated annoyances, they are definitely signs.
Yes. And when those signs appear, the response shouldn't be, defensive. It should be structured, document, investigate, seek expert advice if you need to, communicate appropriately, and of course, if needed, take corrective action. And something else to be aware of that I think is really important: if a resident makes a reasonable modification request, I'm sure most of you listening are aware that in conventional, non-federally funded properties, the resident must pay for their own modifications, right? However, there is an exception to that. If they're asking for a modification to correct an accessibility deficiency, right? For example, to build a ramp to an amenity space that should have already been accessible, management is responsible for paying for that, right? You can't ask a resident to pay to bring the property into compliance. So that's just another really good reason that you should know where the deficiencies lie, if any.
Okay, thank you. So before we close, Leslie, so what is the key legal takeaway from this complaint?
I think the key takeaway is that accessibility failures can obviously create systemic fair housing risk. When barriers are repeated across multiple buildings or multiple areas of a property, the issue may not be framed as just a one-time error, but more so a pattern or practice. And the consequences can be big, they can be significant. In this complaint, FHJC seeks declaratory relief, injunctive relief, physical alterations, policy changes, damages, punitive damages, attorney's fees. So they're asking for a huge amount of money and changes, plus everything to be corrected. So,
Yeah, that's a lot. So it's not just about fixing a mailbox or a threshold. It can become a very large financial and reputational problem.
yeah. And the best time to address accessibility is before, obviously, construction is complete. The second best time to do it is before someone files a complaint. Waiting until litigation is usually the most expensive option.
Yeah, that's a strong place to land. So, Leslie, thank you so much for helping us with this case. A lot of lessons for our community.
Yeah, thanks, Jonathan. And of course, I need to say this is not legal advice. It's just a reminder to work with qualified fair housing counsel and accessibility professionals if and when those issues arise.
Yeah, good point. Good point. Thank you, everyone, for joining us today on Case Files. If this conversation helped you see accessibility compliance in a new way, make sure to subscribe and share this episode with your awesome team. We'll see you next time as we continue turning real cases into practical lessons for our wonderful industry. Take care, everyone.